All right, well, we can get started with introductions and whatnot. Thank you all for joining us today. We're excited to get started. My name is Sean Clancy. I'm here with Delia Rojas. We're attorneys at Emerge Law Group. Delia is a business attorney. She advises on all types of sizes of businesses from her Northern California office. She specializes in business formations, cannabis licensing, and ongoing compliance. She helps clients with corporate issues, restructuring contracts, and intellectual property, which is the topic we're going to be discussing today. Before joining Emerge, Delia was a leading associate at Beck Law and the cannabis legal department there in California. I'm Sean Clancy. I'm a business and intellectual property attorney. I'm the chair of our intellectual property group, and I'm a partner at Emerge. I act as outside intellectual property counsel for a variety of industries, including psychedelics, entertainment, design, consumer products, food, beverages, professional services, technology, software, but a lot of work in the cannabis space. I've been working with cannabis businesses on brand protection issues for, gosh, eight years now. And I think this is going to be a fun topic. So if you could go to the next slide, Delia.
Course.
First, we have to start with our typical disclaimer. This is a presentation for informational and educational purposes. We're not here to provide specific legal advice today. We're not your lawyers during this presentation. So with all of that said, please kind of be aware that we're just trying to educate people and give some information here. Next slide. So two big topics with subtopics, but so we're going to talk about trademarks and other soft IP that's part of branding. This is kind of a 101, so it's going to be a big overview. Each of the different subtopics are specialized areas of intellectual property in themselves. Some attorneys and law professors will spend their entire career just on trademark or just on copyright. So there's a lot of nuance to what we're going to be discussing. But I mean, the goal here is really more to cover some basics and really equip people in the audience, not to like do stuff themselves necessarily, but I mean, there's a lot of things that you will realize are not as complicated as they might have been. But really to kind of set up the contours and the general principles of this area so that you're able to spot issues and like know the kind of biggest pitfalls and how these different concepts fit together. So yeah, it's hopefully to set up this kind of foundational knowledge for everybody to sort of say, okay, you know, you're going to know the difference between a copyright and a trademark, for example. Those are not the same thing, they're similar. And that's one of the things we're going to be talking about. So with that, I'll kick it to you, Delia, to start talking to us about trademarks.
All right, thanks, Sean. Hi, everyone. Thank you all for joining our webinar. So today I'm going to start with discussing trademarks, as Sean just mentioned, and developing your brand. So I'm going to talk about what is a trademark and what exactly is its function, how to choose the right trademark for your business by discussing what types of trademarks there are and what types of trademarks are protectable, how to develop your rights in a mark by discussing the use and registration of the registration process. And then lastly, I want to touch a little bit on what happens after the registration of your mark and how to maintain your rights in that trademark. So first, I would like to talk about the types of trademarks. So a trademark can generally be anything that's distinctive enough to indicate that source of goods or services. So the more traditional and known types of trademarks are going to be word marks, which are words in standard form, which means you're not claiming any type of specific font or stylized form, or you can actually apply for a stylized word mark. There are also symbols, which can be any type of design or symbol. And then there's also logos, which is generally a combination of those words and designs and symbols, and sometimes can actually include those colors. So in addition to those go-to types of trademarks, there are also unique trademarks that you can establish, again, as long as they have that distinctive quality that I mentioned earlier to identify that source of goods or services. So for example, you can have slogans. So a short and striking, memorable phrase. So, you know, like "got milk," "just do it," "I'm loving it." I'm sure you guys can all recognize those specific slogans. There's also packaging. So the Jack Daniel's bottle or Coca-Cola bottles, those are both registered trademarks. A color, the Tiffany's blue is a registered trademark, and sound can even be a trademark. The MGM actually has their roaring lion, so that lion sound that you hear at the beginning of the movies. And again, the most important aspect of these would be the distinctive quality that they would have. So what exactly does a trademark do? So the main objectives of a trademark are to, first and foremost, as I just mentioned, to identify that those goods or services from originating from a particular source. And then ultimately, they're going to distinguish your goods or services from others in the industry. Secondly, trademark law looks to protect the consumer from being confused about the source. So confusingly similar marks, preventing those in the market. And lastly, as I just mentioned, you're going to prevent those confusingly similar marks, so it protects that business and their distinctive trademark in the market. So overall, the fundamental goal of a trademark is to act as an indicator of source and help those consumers decide whether to purchase that desirable product or not. It also provides a strong, if your business provides that strong and consistent product attached to that trademark, your company is going to create an overall goodwill and brand awareness over time. And you're going to gain that consumer trust, which is really what you're looking for. So eventually, consumers will be able to choose products and purchase those products or services solely based on the recognition of your brand.
Yeah. It's kind of like, it's all about these search costs, when there's so many different products in the marketplace. And so what trademarks do is they make it easy. You say, okay, I just see this one symbol and I know it's the thing that has the qualities that I like. And so there's kind of two sides of it. There's that reduced cost of like, okay, this symbol means that thing to me or as a consumer. And then it's a reward to businesses who've done a good job. And it doesn't have to be a high quality thing. Like, quality could be cheap. Like we know that, okay, this mark means like the cheap, but good enough, so we know, okay, that mark becomes valuable for signaling that quality being attached to those things. Thanks to trademarks, I can go online and order a pair of pants, Levi's 511. I'm not going to tell you my waistline, but like, I know I can order it and it'll arrive and it'll fit, which is like, and I mean, thinking about cannabis too, like I can go to the store and I can get the drops edible that I like and the flavor that I like, and I know the dose and I know exactly what will happen to me because I've done it before. And it sort of rewards that like tie-in of this symbol means that thing.
Absolutely. All right, so how do we choose that mark? How do we get that trademark? So when choosing your trademark, it's generally tempting to kind of choose a word that is catchy and describes your feature of your goods or services, because it basically, you want to try to reflect the business or what you're trying to sell or do. But unfortunately, in trademark law, that's not the route that you would want to take. When you're choosing your mark, you're looking for a mark to be 1, distinctive, and 2, exclusive. So the distinctiveness of the mark is measured by the overall strength of the mark. So what you're looking at is the mark in relation to the goods or services that you're attaching that mark to. So as you can see on this little chart that I have on the screen, the strength of the mark can range from weak generic marks, which are not registrable or protectable, to strong and fanciful marks, which you can protect and get registered as long as there's no conflict with other marks that are in use. So just to go into each type of category really quick. So we have generic marks, as I just mentioned, they're not generally registrable or protectable. They refers to a term that has become very common in that, a common name or term for that specific trade of goods or services in that industry. So these are terms that most people or competitors will actually need to use in describing or referencing their goods. So rights cannot necessarily be granted for those specific terms. Some examples would be, as I have here, retail store, delivery service, bakery. For cannabis would be one, bud, flower, things like that. Those could be generic terms. So the next down the line would be descriptive. These are terms that describe an ingredient, quality, characteristic, function, feature, purpose, or use of those goods or services. So an example would be Sports Illustrated for a sports magazine, E-Trade for electronic trading, or Mendocino Green, for cannabis. So these terms describe, a specific aspect of your goods or services and are generally not protectable or registrable on or with the state or federal jurisdictions unless that mark acquires what's called a secondary meaning. So certain terms can acquire that distinctiveness in relation to your brand, to your goods or services, and generate those trademark rights with extensive use or advertising over time. So next would be down the line with suggestive marks. Now, suggestive marks are ones that suggest, not necessarily describe the ingredient, quality, characteristic, function, or use of those goods or services. So suggestive marks require a little bit more of a leap of imagination or thought to connect the trademark, your mark that you're trying to use, with those goods and services that you're trying to attach it to. These types of marks are protectable and can be registered. And an example would be Copper Tone for tanning lotion or PetSmart for a pet retail store. Now, moving down the line, we have arbitrary terms. Now, these are terms that are in words that have dictionary definitions, but are unrelated to those goods or services that you're trying to attach them to. So one of the most famous, one is Apple for computers. And generally speaking, these are protectable and are able to get registered unless in conflict with another mark. Lastly on this list right here, we have fanciful marks. So these are words that are made up and have no meaning besides the one that's connected to your brand and your goods or services. They generally receive the broadest scope of protection and are seen as the strongest marks and are generally registered and protected unless, again, in conflict with another mark that's already in use. So for example, you have Kodak for cameras and film, or Xerox for copy machines. So next, as I mentioned, besides the distinctiveness, you would need to have, you are looking for an exclusive mark, meaning that you want to make sure that there aren't any other identical or confusingly similar marks that are already used in that market for those same goods or services. So I mentioned earlier, trademark law looks to, one, protect the consumers from confusion as to the source of the goods or services, and protect the business from others coming in and benefiting from that goodwill of that brand. So keeping those in mind, it's important that you choose a mark that's as exclusive as possible. So this not only avoids infringement in the future, but ultimately is a benefit to your business because it allows consumers to recognize your brand and distinguish it from others in the market. So prior to use of the mark, it's best practice to research the proposed mark and to see if it's already in use. Once you are comfortable with that trademark, it's highly advisable to seek professional assistance from an experienced attorney or trademark professional to conduct that knockout search and in-depth clearance for your mark. Trademark law, it looks at different numerous factors and nuances that create a likelihood of confusion, which are determined on a case-by-case basis. So we look at the similarity of sight, sound, commercial impression, and again, it's all on the case-by-case basis in reference to those goods and services that you are offering. So when you're comparing it, it's not only the goods and services that are identical to yours, you also have to consider related classes. So the USPTO, so the United States Patent and Trademark Office, and courts will look at connections between those classes, and if they're related enough, they might be confusingly similar. So let me give you an example. So let's say that you are selling, coffee beans, and you have your trademark for coffee beans. If someone wants to open a coffee shop with the same trademark, they might be blocked from doing that because you already have those coffee beans and there's some sort of connection where consumers could have that confusion. So you have to be careful for not only identical goods and services, but also related. as well.
Yeah, and I think it's worth, pausing here that the kind of gold standard for its trademark infringement, deciding that one trademark infringes on another and blocks another, is likelihood of consumer confusion, which, as much as anything, sounds like sort of psychological, but it's a court or decider looking at these two businesses, and they ask how similar are the marks. So the marks themselves, as they appear, as they sound, as they are spelled, but that not just in isolation. They also look at how distinctive are they. We go back to that spectrum, like is it more descriptive? Is it suggestive? Is it actually fanciful or arbitrary? If it's stronger, that would maybe weigh towards more likelihood of confusion, more likelihood of infringement. And then how similar are those goods or services? Is it possible that the trade channels could expand though? That's also a factor in the analysis. So if I'm have my coffee shop that also sells ground coffee beans and roasted coffee beans, what about tea? What about muffins? There's an argument there that like these things start to get close enough. So I think it's worth, especially when you see the results of a knockout search, to be conscientious about what kind of risk you're realistically looking at, who the specific competitor is. Courts also look at how sophisticated are the consumers in a particular market. So if we're talking about just basic consumer facing, courts will probably assume they're less sophisticated. But if we're talking about a specific business to business product with like maybe a very expensive price tag, maybe consumers are less likely to be confused because a little difference in the two marks might be enough for those types of consumers to tell them apart, and there won't be confusion. We also look at how famous is the mark. Like if there's one, if you're coming to me with something I can see at the front aisle of my grocery store, I'm going to have a lot of trouble telling you that's going to be a safe mark to use. But I mean, this step is huge because it's a lot of people launch their businesses without searching it. And they're basically, it's as much as your real estate, this is your brand territory. Like, how do people find your business? They look for the brand, they type it into their search function, or businesses, people on the phone sharing the name to each other. So you want to be thinking about, like, is this safe territory to start to set up your shop and go out there and especially expand too. There's a difference between, of course, getting away with using a name. Like if you're just going to be the speaking of cannabis dispensaries, if you're just going to be the basic green cross at the corner, maybe who cares? Like maybe you're just a volume business, whoever comes and goes, your physical location is what matters. You don't care about the name. You're not going to franchise. You don't want to expand. You're not going to have your own products. You don't care. Maybe that's fine. And like in that case, maybe a descriptive or generic name really doesn't matter. But if you're going to be expanding, or you're going to be trying to license, or you're trying to create a piece of property here that can be, sold to people later, that will accrue value, then you want to look into this. And you're not just trying to safely operate, you're trying to actually create something to own it. And then you want to look at this stuff.
Absolutely. All right, so before I, discuss into use of the mark, I wanted to quickly touch on a couple popular cannabis terms that people like to use in their trademarks. So many operators, what I've seen, like to include geographic location of the mark, which is understandable given the familiarity of certain regions here in California, specifically, Mendocino, Humboldt, things like that. But unfortunately, using a geographic location of the goods and services is generally considered descriptive. And as discussed earlier, likely not protectable unless it reaches that threshold of secondary meaning. But not only does this apply to actual names of the location, so Humboldt, Mendocino, but it also applies to well-known geographic nicknames. So the Emerald Triangle would be one as well. If, on the other hand, your goods or services are not from the area that's within the potential proposed trademark, it is still likely not to be protectable because it would be some sort of misrepresentation of the goods or services. And I want to just quickly note right here that using a geographic location as a trademark is separate from the California Appellations Program or a city or county of origins program. Appellation labels and city of county of origins recognitions are separate types of IP that have different requirements and regulations that govern those associations and use. So that's completely separate from using your geographic location as a trademark. So another common situation is using a name of someone or their likeness or portrait. So for example, you have Marley Natural is an official brand of Bob Marley that was started by the estate of Bob Marley. The USPTO will register names, portraits, someone's likeness as long as you submit written consent from that individual that you're trying to represent, or in the case of Bob Marley, like I just mentioned, his estate that is being referred to. So that goes also, it ties a little bit into publicity rights, which Sean will touch on a little bit later. But another common category of terms would be slang. And Sean, I think you want to touch on that a little bit.
Yeah, I mean, slang is so interesting to me because I mean, there's this rich vocabulary that's, I mean, cannabis has been around for so long, and there's this legacy, gray, black, underground, traditional market, whatever you want to call it. And there are all these words that have been used there and they still have meaning. And on one hand, using those words creatively, that makes sense within the kind of trademark policy of rewarding businesses for identifying source and that sort of thing. But on the other hand, you know, a lot of these words are used by everybody. And for one individual or business to come in and claim them and claim that they own them, I mean, that's what you're saying when you're trying to claim exclusive trademarks, is within the field that you own it. I mean, that, I don't know, it's a bit of hubris. And so things like bud or dank nugs or sticky green, you know, those are kind of funny words. Or I mean, you look at some of the names that have been used for strains, you know, they're silly, but at the same time, they also describe the thing that we're talking about. It would be unfair for one particular entity to control them. At the same time, there are plenty of growing successful brands in the cannabis industry who've latched on in some part, maybe, to some sort of formerly slang term. The thing is with those, you can think of it again, like go to kind of like my real estate analogy. That's like more just, it's maybe popular territory. It's like a high traffic area. People like those words. People use those words. They know what they mean. But because it's like a popular high traffic brand zone, that means that it's going to be competitive. It means it's going to be more expensive to defend if it's even possible. So I mean, it's almost like a kind of a turf war. You know, whoever gets on the best spot, the best corner. You know, if somebody's there, you know, I'm claiming dank nugs, like that would be tough to defend. If you could get it, like you'd be in a high traffic zone. But I mean, I think you'd be facing a lot of competition, and it's safer to go with something that's like maybe a little off the beaten path, or at least has some sort of variation that's not just the word that people already use. And that's my little speech about slang.
All right, thanks, Sean. All right, so now I'm going to move into talking about how do you acquire those rights in your trademark. So you acquire your rights by using that trademark. So once you start using your mark in commerce connection with your goods and services, you start to begin to gain what's called common law trademark rights. So that use in commerce is looking at the type of use and the amount of use. And what you're really looking for is to attach, again, I'm going to be using this word a lot, the attaching that trademark to your goods or services. You want it to be a little bit more than what's called a minimal use. So it can't just be, you know, your business name and that's going to be your trademark for everything that you have. It needs to be, again, that attachment feature to your goods or services. You want to make that correlation in the consumer's mind with your trademark to your goods and services that you're offering. In addition, the focus is really to have a continuous attachment. So you want to make sure that whenever you are offering your goods or services to consumers or in the market, you want to make sure that you're continuously using that trademark attached to those goods or services as well. So once you've chosen your mark and you're starting to use it in commerce, the next step would be to look at trademark registration. There are two levels of trademark registration you can apply for. You have state and federal. Each state has its own set of regulations that govern trademark registration. However, they're all relatively similar. Most, if not all states follow the same classification system and overall review criteria that the federal USPTO uses. But in comparison, the state process can be simpler and a lot quicker. Most applications are processed within 4 to 8 weeks, depending on the state. But it's one thing to note and really important to instill about a state registration is that it's protecting your trademark within those state lines only. So if you're having one, let's say in California, it doesn't mean that your mark is protected in Nevada or any of the other states. So with that in mind, next you would want to think about federal registration, which would expand on those state rights and provide you with national rights to your trademark and other benefits. A federal registration actually provides a national public record that puts others on notice of your trademark. 2, presumptive evidence that you actually own that trademark and that you have that exclusive right to it. Next, you could use that registration to file international applications. And then lastly, it provides certain damages during lawsuits if you find an infringing mark that you would like to stop their use. So on the federal level, I want to note here that the USPTO offers 2 types of applications. You have a use-based or an intent to use-based. Now, the use-based application means that you are already using that mark in commerce, whereas intent to use means that you file that application with a bona fide intent that you're going to use that mark in the near future. So one of the main benefits of an intent to use application is that it puts others on notice of your future use to prevent others from registering a confusingly similar mark. So looking at the application and process, I just want to note one of the most important aspects of your application when you file, which is your identification of your goods and services. Your identification is going to fit within one of the 45 different classes that the USPTO has. Now, classes are essentially categories. So there's 45 different categories that you can register a potential mark in. And when you're putting together your list of your goods and services, it needs to be clear and precise. And you want to make sure that it's broad enough to encompass all of the goods and services that you offer, but not overbroad to include terms that you do not produce. It's very important to be precise in this identification, because once you file that application, you cannot broaden your identification, you can only limit it. So if, for example, you start selling something else, later down the line, you're going to have to register for that separately once you start offering that under your trademark. So the process of registration is quite long. I just want to let you guys know that it's gone a little bit longer with the pandemic, unfortunately, because of COVID. It takes about 6 months or longer just to be assigned to an examining attorney to review your application, where it used to only be 3. And, with what's going on now, best case scenario is that your application will be reviewed, within a year and be processed within a year if there's nothing, no pushback by the USPTO. But what can happen is that, if your application, once it's reviewed, they do find an issue with the application, they can issue what is called an office action, which they're requesting additional information or explanation about your trademark in relation to your goods and services. If you do receive that office action, you're going to have to respond, which again will just take make that process last a little bit longer. Once you submit that response, the examining attorney will review, and then they either can accept that response and then move your application forward, or potentially deny your application, where you would have to respond and plead your case once again. So regardless of how long the process takes, I just want to say it's important to remember that once you file your application, you do have that priority filing date. And as long as you're using that mark in commerce, you are broadening and strengthening your rights in that trademark. So one last note I want to make on this slide is the difference between the commonly known trademark symbols. So as you can see here, you have the TM and the R with the circle. Anyone can actually use that TM symbol prior to registration to indicate, the use of the mark as a trademark, kind of putting others on notice that you're going to be using that mark as a trademark. And then once you receive that registration, you're allowed to use that official R with a circle symbol to indicate that you do have that valid registration and exclusive rights to that trademark.
Yeah, a lot there. I just to like kind of hit the highlights. I mean, so like we're talking about building the brand, so you kind of start with that first common law use. Like once you start using it, attaching the mark to the goods, using it with the services, using the mark, there's common law rights. That means that competitors out there who are using the mark, even if they don't have a registration, they're an issue. So whoever's using first, that's the baseline. That's also sort of throughout, regardless of registrations or applications, probably the most, if not the most important thing is how is the mark actually being used? After that, you get your state applications, especially useful in the cannabis industry, because as Deli's going to talk about, there are issues with federal law and getting federal trademarks, but your state registrations can give you then these additional kind of territories and rights. Beyond that, we've got our intent to use application where we can apply based on intending to use the mark with specific goods or services. And then eventually we can get to a use application and registration by proving that, okay, nationally in interstate commerce, legal interstate commerce, we're using this mark with these goods. And then that can eventually get you that circled R if you want it. Some international companies actually don't use the circled R because they don't like making different labels for different jurisdictions, but the circled R is special and reserved only for federal registration in the United States. Anybody can use the TM. You can go out and start using it right now, subject to being, kind of tacky with it. You don't want to put it on everything, but you go for it.
All right, so now, okay, so we talked about common law rights, registration. So it seems, once you got that registration, that logically you would be done and everything would be set in stone. But unfortunately, that's not the case for both state and federal registrations. The USPTO and most states require certain filings and fees throughout the trademark registration to keep that active. Your trademark will remain valid as long as you file those required documents prior to deadlines. And if you don't file the documentations, the USPTO or the state, whichever one you're looking to, will levy your registration either abandoned or inactive, which can have various legal implications and potentially jeopardize your rights and your mark. So in addition to the ongoing maintenance, filing all of this additional paperwork over time, in order to protect your rights as an owner, you'll need to conduct ongoing policing of your mark and quality control of your mark. So you can actually lose or jeopardize your rights and your mark by, I'm just gonna kind of go through the list I have here for you guys. So improper use, if you fail to continuously use the mark as a source indicator, so failure to attach it to the goods or services that you're offering. So just continue to make sure to attach it as much as possible. Non-use, if you stop using the mark, trademark law only protects marks that are in continuous use. Third, I want to talk about improper assignment or licensing. Now, I want to take a little bit extra time on this one because it's very important. Trademark law requires that the owner remain in control of the overall use and the quality and how it's used. If you are licensing your mark, it's imperative that you have terms in your contract that allow for some oversight and quality control of that mark as someone else uses it in the market. The terms are essential for white labeling situations to ensure that continued ownership of the mark. So if you do not have those rights to that quality control or review of your mark and how it's being used, that can jeopardize your rights on that mark. As for an assignment, if you don't execute and file the appropriate documents to assign that mark to another individual or entity, this can potentially cause issue for who the owner is later down the line and if the mark is being used properly. So for these situations specifically, I highly advise reaching out to an experienced trademark attorney to assist with any sort of assignment or licensing to ensure that, you know, continued protection and that everything is done properly. The next would be failure to police. As the trademark owner, you are required to police your mark, making sure that no one else is using the identical or a similar mark. When you do find that a potentially conflicting mark, make sure to discuss with an experienced attorney on how and if you would want to move forward in stopping their use of their mark. Because as we discussed earlier, there's a huge list of factors that would have to be considered on if it is confusingly similar and if it is appropriate to move forward to stop their use. Next, I have cancellation. So cancellation is a USPTO proceeding where third parties actually file to request the cancellation of your registered trademark due to alleged damage or some sort to their mark. The proceeding itself is very similar to litigation, so it's a very long, expensive process, and that can actually happen at any point. So that's where exclusivity and distinctiveness can become really important, because if there isn't that exclusivity, then there are potentially other marks in the market that might, come up later down the line after you have that registration. And lastly, I just want to quickly touch on there's new trademark proceedings, and as of December 2021, they were put into play. These are for basically the purpose of the new proceedings are to help the USPTO in addressing a clutter of registered marks that aren't actually in use, or they were registered with an inaccurate identification of those goods and services. So they were either potentially overbroad and are claiming rights to goods or services they don't actually offer. So these proceedings can actually force an expungement of an application or revision of your identification. So like I said, this reflects just how important it is to have that precise list of goods and services. And if you include something that you're not actually offering, you might have to go remove that later at an additional cost. All right, so what about cannabis brands? So with all that information in mind, I want to just first touch on federal registration. As Sean mentioned, is only allowed for lawful use of goods and services. So due to being a Schedule I drug, you still cannot apply for a federal trademark registration for cannabis or cannabis products. If the USPTO detects that it's not a lawful use, not lawful goods or services, they can issue an office action, which I mentioned earlier, to inquire more information, making sure that your goods or services are lawful. And if they find that it's not, they will deny that application. But if you do provide that response to where you can show that you are compliant, they'll go ahead and move that application forward. So this particular, this could potentially cause a delay in your application process if they're, if they potentially think that there is some sort of unlawful use. So any connection to cannabis or cannabis products. But what you can do is file a federal application for what are called ancillary goods and services. Now, these are goods and services that engage in the industry, but are not necessarily touching the plant, so to speak. Many businesses file for clothing, uninfused foods, smokers articles like lighters, rolling papers, things like that, education or business services. However, on the state level, generally speaking, states that have that legalized commercial cannabis allowed, they actually allow for businesses to file those trademark applications for the registration of cannabis and cannabis products. So just keep in mind that each state is different. So the application, the fees, and class numbers may vary from state to state, but like I mentioned earlier, they are most generally are in line with the federal classification system. But a few of the common classes that I've seen for cannabis and cannabis products would be class 3 for cosmetics, which are like topicals, class 31 which are natural agricultural products. So like your little your little clones, things like that. So a nursery might want to do that. Class 34, again, smokers articles, which could be joints or other types of smokable products too. I've seen a lot of states like it in that class. And then lastly, class 35, so you can have those dispensaries or retail services or advertising or things like that. So even though you can't necessarily register them on the federal registrar, you have ways to protect your rights within that state, and then build on your brand from there. So at this point, Sean is actually going to start talking to you guys a little bit about other types of soft IP.
Yeah, thanks, Delia. Good stuff. Trademark is definitely the highlight, I think, of branding. Most people are most interested in that, and so I think hitting those key issues of usage and then control is the other one. Like, trademark's all about controlling and using the mark and controlling it, using the mark and controlling it. The more that happens, you're in a good way. But what else can you do? So two big pieces of sort of intellectual property would be copyright, or there's a bunch of rights, but I'm going to refer to name, image, and likeness rights. Those are both sort of similar but different types of intellectual property. So the first one, copyright, defined as original works of authorship fixed in any tangible medium of expression. So we've got something original, authored by somebody, and it's fixed in a tangible medium of expression. So these include literary works, which include software. You can write software like literary works, musical works, dramatic works, graphic design works, sculptural works, photos, motion pictures, audiovisual works, sound recordings, different from written music. I won't get into that whole distinction, but music, and then architectural work. So all of these different types of things that have this creative component, and they're fixed in a particular medium of expression. The other rights, it kind of depends on what context they come up, but name, image, and likeness rights, basically surrounding people who have faces, most people, and names. If you have a name, then you potentially have rights that you can grant and share, and then you can get something in exchange. If somebody does something with your face or your name without your permission, again, depending on the context and sort of the whole, which is, a big depending, but depending on it, there are other rights in play there that might result in, there's stuff you can mess around with legally. So go to the next slide, please. So copyright, I think in the cannabis industry, this is particularly useful, and I think often overlooked, or to date it's been overlooked. I think people are finally starting to catch on. The copyright is not to be dismissed. It's cheap. It's like $60, $65 to file one copyright registration. There's no lawful use requirement. So when Delia was talking about all these challenges and like the whole interrogation process and the invasive questions that the trademark office will ask you if they think you might be a cannabis company, doesn't matter in copyright land. Copyright only covers the work of creative authorship though. So that design, that photograph, so it doesn't necessarily bleed into the commercial aspect of it, but it is a federal registration that gives you rights throughout the country, including a right to seek attorney fees if somebody copies your creative expression. So the photos, again, written articles, written web content, visual web content, designs and logos. These are all things that could be applied for and registered and protected under copyright. Again, there's no need to attach it to the goods and services. Trademark, you have to have the mark attached to goods or services. With copyright, you don't have to. The thing is, they're narrower. So like as trademark, you've got this standard of likelihood of consumer confusion. To determine infringement, is a consumer likely to confuse the two brands, which is a bit broader. We talked about the expanding of market territory. In copyright, it's more aimed at preventing copying. So as in something that's ripping off the design, counterfeiting. There's a bit of wiggle room around derivative works. So if it's clear that a later work is derived from something to the point that they've copied it, that is a right that the original copyright owner would be able to enforce. So if we go to the next slide, please. So yeah, apps, I mentioned software, and we're talking about the written software code here. This is not the idea of the app and what the app does. The copyright is, again, sort of narrow, and then it covers the creative expression. So like that version of the software, that edit, that draft of a written work. A wholly different coded platform that didn't steal anything from something else, but if they do the same thing, that's not a copyright problem. Like if somebody independently created an app that does something in a different, like maybe even the same, accomplishes the same thing as an app that was created by someone else, that's not copyright infringement. Maybe there's a patent issue there, but that requires patent registration. We're not talking about patents today. Copyright's all about the creative expression. If somebody is copying and pasting wholesale from the software of an app, then we'd be talking about copyright issues and sort of what the ownership of the app is, and what's the, that sort of thing. But there's this distinction then that's important to keep in mind if you're talking about owning copyright, between the idea for the thing that would be described or is made tangible in this creative expression. The idea is different from this particular expression. So the idea of an app that lets you play music on your phone, there's multiple different companies could compete and make that same type of app. Until they're actually copying each other's code, they're not violating copyright. Next slide, please. Also mentioned architectural works. This is less frequent. It's usually not a high dollar thing, but it is a thing. I mean, it's the reason you pay architects. An architectural plan for a greenhouse or processing facility is a work of creative authorship with an author, people applying their creativity and their skills to create a design. But again, the copyright will protect the expression, like that fixed version, that written version. If I copy that expression, that's the realm of copyright. The idea for a greenhouse with, parallel beds and like an exit here and like sprinklers there, that idea by itself alone is not protected by copyright. Next slide, please. Again, here we've got an example of something that's functional. We've got pipes, but there's definitely creative components. So to the extent that there's a function here, a bong, like that, the person who designed this bong doesn't own the idea of a bong, obviously. But what they do own, unless they've assigned it, is this creative expression. So all of the creative choices that happened around these, those are the realm of copyright. You go to the next slide. So these obviously are this is a violation of copyright. The idea of the bong is fine, but this expression, in fact, copies properties that our good friends in Anaheim at the Walt Disney Company own, and they would have a problem with that. So don't copy somebody else's expression unless you have their permission. Next slide, please. So yeah, I sort of mentioned this before, but I think this is a really key kind of point to take away when you're thinking about copyright, is there's this distinction between the idea and the expression. There's a strict recipe, which would describe, a process. You don't control the process if you're the person to write it down. If there's a narrative around the process, and if there's this more kind of creative expression surrounding it, that gives you something that can be protectable under copyright. You see this often online with recipes. There'll be this, narrative of how I learned this recipe from my grandmother, and it was her favorite cocktail, and she'd have 10 of them every night, and it was so fun. That written description is protectable by copyright. The recipe itself, in the middle of it, that's just the idea for the thing, and so that would not be copyright. So copyright protects more than just short phrases, names, or expressions. That's something that trademark can do, that copyright cannot. At a certain point, though, once the phrase is long enough, and there's no kind of clear standard for this, but I mean, at a certain point, when you see it, maybe a haiku, certain song lyrics that are long enough and not cliche, At a certain point, those can be protectable by copyright, though. Again, designs. So to the extent that anybody is hiring a designer to create material, that material assume will be the realm of copyright. So with that said, a very important point that most people don't realize is that by default, the creator, the author, owns the copyright in the work. So unless they're an employee, which is usually pretty clear, but when I say employee, I mean a legal employee, W-2, on payroll, and then operating within the scope of their employment. In that case, an employer can own the copyright in what the employee creates. If I hire a photographer for the purpose of taking photos for my business and maybe doing web content for my business, that's their job description, they're an employee. Okay, I don't have to worry that like maybe they own their material. If I hire a bud tender and they happen to have a graphic design, talent, and they make logos at home off the clock, that's outside the scope of their employment. Even though they're an employee, they don't own the copyright to that. Work made for hire, also, like if there's a work made for hire, then you will own the copyright to who you hire, or to the material that they create for the purposes for which you hire them. With those are exceptions, right? So with that in mind, pretty much anytime you're wanting somebody to own the copyright who's not the person who's fixing it, like if you're wanting a company to own it, it's best to get a written agreement, because if there's not a written agreement, they will by default own it. So there's all kinds of businesses out there who've hired, freelancers and design companies who are, very talented and experienced and stuff, and they'll send an invoice, but there's no written record of who owns the copyright. And so if you want to own the copyright, if you want it to transfer from the original author, assume that you need to get it in writing, just that this transfers. And it's not a big deal. It could be just a short little transfer statement, but unless there's a written statement, it's in the copyright statute that the original author owns it. So one to keep in mind. If we'll go to the next slide. Another sort of related area for when we're speaking about brand is the publicity, privacy, name, image, and likeness. And so different sort of bodies of law where these rights kind of come up. One is called publicity rights. Those vary state by state. They've been kind of come out of common law and courts and people suing each other over perceived damage. So some courts see it as a property interest, which isn't like something I own my face, and it's like if you're using it, it's like I'm letting you use my property. Some of it see it actually as kind of a tort claim. So it's like if you use my face without my permission, you've damaged me. You can kind of see like the difference there. But suffice it to say that there are rights if you're using somebody's face or image or likeness. California has and New York, Tennessee, places where there's been a lot of famous people living, as you might imagine. That's actually where a lot of this case law is developed. Yeah, so it might actually not apply in some states. So in Oregon, there's very loose laws around privacy and publicity. It's very much a free speech state. So people who are, using words to express things, they're generally more protected. But that's not to say there aren't those types of rights that can be used in Oregon. There are other legal theories in play if you're dealing with somebody's name or face or likeness. It could potentially be an invasion of privacy, depending on image you're using, defamation, false light, false endorsement. Those are all kind of related to essentially putting commercial speech into someone's, making it as if they're endorsing something that they aren't. That's always something that's tricky, especially in the cannabis industry, where there are these kind of known names and players out there. Operating without their permission is risky if you're using their name. I think the case of strain names is interesting because those have sort of gone out in the marketplace without anybody's control. So query whether or not Charlie Sheen might be able to stop people from calling a strain his name. He does have those rights. He does have rights he could try to enforce. It would be very difficult, I think, and arguable whether or not it's really implying that he's endorsed it, but maybe, I don't know. It's definitely an issue though. And then also, of course, if you're using an image that contains a person's face, even if it's, just be careful of whose face you're using. If you're putting images on your website or you're advertising and it's reaching a certain volume and a certain size of audience, there's potential issues with all of these potential theories. Maybe the person doesn't want to be associated with cannabis. Maybe they don't care, but maybe they don't. So thinking about if you're using a person in your brand, what that means. If we go to the next slide, please. And I think this is our last one, just coming in towards the end. The nice thing though about these sort of cluster of rights is that it's something else you can apply to a brand, and it's especially handy in the cannabis space because of the limits on lawful commerce, because you cannot get federal rights through traditional trademark registrations as easily. Actually using somebody's name, you kind of supplement your rights with all of these name, image, and likeness theories. So if I'm Mike Tyson, or a company that wants a name that will give me rights in states where Mike Tyson has a reputation and claims to his person and likeness, if I can slap his name on my candy, or Willie Nelson's name on my cannabis, I've actually got a better chance of enforcing those rights and controlling those brand, not through trademark, not through copyright, but through, well, maybe through those two, probably through those two, but also through these name, image, likeness rights. These are fun deals. They get very complicated though, because usually, when you're talking about these personalities and these people, they're often their image is a business already, and so there's some interrelated companies. Maybe there's a music deal involved. There's other things, So I would say this is the most advanced level of a branding kind of strategy to get involved with this, but it's also one of the most fun. So with that, I think that was our last slide. I'm happy to stick around for questions for a little bit if there are any. And like I mentioned in the chat, I think we're planning to post this on YouTube at some point. Or if anybody's shy, they can always email me or Delia. We're happy to answer questions.